Welcome to Immigration Info, your ultimate hub for all things immigration. Looking for visa tips, country guides, and the latest immigration updates? You're in the right place. Subscribe for expert insights and join our global community today.
An attorney defending Texas' controversial immigration law told a federal appeals court on Wednesday that state legislators may have gone too far when they passed the law last year. The law, known as SB 4, makes entering Texas illegally a state crime and allows state judges to order immigrants to be deported. At a hearing before the 5th U.S. Circuit Court of Appeals, Texas Solicitor General Aaron Nelson said that when designing the law, lawmakers sought to go up to the line in terms of what Supreme Court precedent allows states to do. But, Nelson added, now, to be fair, maybe Texas went too far. Nelson is arguing before a circuit panel that has already paused the law from going into effect while the court further examines the statute. Nelson sought to downplay how sweeping the law was and argued it did not interfere with federal authority on immigration. On Wednesday, Nelson said that under the Texas Attorney General's office interpretation of the state law, the migrants subject to state court deportation orders would be turned over to federal immigration authorities at border ports, and then the federal officials would determine whether they should be released into the United States while they await further proceedings. Chief Circuit Judge Priscilla Richmond, a conservative judge who was the key swing vote in the 2-1 panel decision last week that temporarily paused the law, was skeptical of Nelson's attempts to limit the state law's scope. An attorney for the Justice Department, which brought one of the lawsuits challenging the Texas statute, urged the appeals court not to depart from its previous ruling blocking the law. Nothing that has happened this morning provides any basis for deviating from the analysis set out in this court's stay opinion, DOJ attorney Daniel Tenney told the appeals court Wednesday. Judge Andrew Oldham, the only member of the panel who appears ready to uphold the law, peppered Tenney with questions that sought to undermine the arguments pushed by the administration and other plaintiffs in opposition to the law. Never in the history of the nation has the United States achieved what they've achieved in this case. It's an extraordinary achievement that the United States has won. Nelson, meanwhile, told the court that SB 4 was the state's attempt to enforce federal immigration laws he claimed the Biden administration was ignoring. Of course, we know that presidents come and go, and different administrations might very well enforce federal law differently, he said, arguing that the law may not be necessary under a different presidential administration. He went on to say that if the court finds that some aspects of the Texas law are invalid, it should not strike down the entire law, but instead sever those parts to let the other provisions remain on the books. Wednesday's hearing was the latest episode in a complicated legal drama surrounding SB 4 that has seen the law take effect for several hours one day last month after the U.S. Supreme Court permitted its enforcement, only for the appeals court to block it in an unexpected order later that night. The law was initially blocked by a federal judge in late February. The preliminary injunction came in response to lawsuits brought against Texas by the Biden administration, El Paso County, and 2 immigrant advocacy groups. In the order last month denying Texas' request to enforce the law while their appeal of the injunction plays out, Richmond said that the law likely violated the Constitution and Supreme Court precedent. Legal experts have said that if the Texas case lands before the High Court, it could give the justices a chance to revisit the 2012 ruling and potentially upend the federal government's long-held authority over U.S. immigration matters.